Now, as we just mentioned, police are not calling Raymond Clark a suspect in the case, but rather a person of interest. We're looking at the differences in those terms today. What does a person of interest really mean? Why is it used? And what ramifications can it have? Our blogger bunch joins us today to help walk us through. While I chat with them, Reggie will be keeping an eye on what you were saying. We'll be hearing from him in just a minute or two. Right now, I want to introduce our bloggers to you. First up, we have attorney Paul Callan of Callan, Costa, Brady and Brennan, which you can find at ckbblaw.com. Welcome to you.
Nice to be here.
And also we have Cynthia Hujar, president of the National Association of Criminal Defense Lawyers. Their website is nacdl.org. Hello, Cynthia.
Hi there.
All right, let's start with this difference between a person of interest and a suspect, because we have Raymond Clark being named as a person of interest in the death of Annie Lay. We remember, for example, Michael Vick was called a person of interest before he was arrested on dogfighting charges. But what really is the difference? Paul, will you lay that out for us?
Well, it's very interesting. When I was a prosecutor here in New York City, we never used that term. Everybody was either a suspect or not. But this sort of came into fashion after the Richard Jewell case. Remember, Jewell was, I know you remember because you're in Atlanta, but he was the guy who was accused of almost having, I think, detonated a bomb at the Olympics. And
yeah, 1996.
He was called a suspect, and he was, for a long period of time, he was called a suspect. And it destroyed his life, and he eventually started a lawsuit. I believe it was a successful lawsuit. So I think the police are very, very careful now when they escalate the terminology to the suspect level. So kind of a person of interest is one level below that of a suspect. Now, it probably in reality means the same thing, but in a civil lawsuit later on, they would say, well, we never accused you of a crime. We just said you were a person of interest. And I think the second reason they kind of like using this term is because it lures the suspect into thinking, maybe it's okay to cooperate with the police. I'm not a suspect. I'm only a person of interest. So they probably feel that they're going to get a more cooperative witness as they continue the investigation. But it's really a distinction without a difference that's come into being in the last 5 to 10 years.
So, Cynthia, would you essentially agree with that this is a term that is used to avoid lawsuits primarily?
I don't think I would agree with that. I think everyone understands what a person of interest means. It means a suspect, and Richard Jewell was successful for the use of that term against him as meaning the equivalent of suspect. But I do agree with Paul that it's intended to keep the suspect's suspicion that they're under suspicion down, so they'll be more cooperative, not seek legal help. And another thing it does that Paul didn't mention is oftentimes it allows the police to escalate against an individual when they really don't have any evidence. That's where we've seen it used. Someone's a person of interest when they don't really have any evidence of their wrongdoing, and then they get so focused on the individual because they've used that terminology. And unfortunately, we saw in the case of Richard Jewell with the individual accused of distributing anthrax and other cases, sometimes it leads law enforcement to focus on the wrong person for too long a time, and they miss out on the real suspect. I don't know that that's the case here, but that's certainly been the history associated with the use of the term.
Well, I think, though, Cynthia, the only thing I disagree with you with respect to that is that the police can make mistakes whether they call somebody a suspect or a person of interest. I mean, you and I both do criminal defense work, so we've all seen situations where the wrong person gets caught in the eyes of the prosecutor, and whether they're calling him a suspect or a person of interest, if there's going to be a mistake, I don't think the terminology increases the likelihood of a mistake.
No, but I think the terminology, Paul, is used when they lack evidence, and that's when I've seen it used. And I don't know that if that's the case here, since a search warrant obviously did issue for this individual's home. Maybe this is one case where they've used the term where they actually have some evidence. But in the past, I think it's a loosey-goosey term, and I think we ought to get back to terms that we understand the meaning of.
Let's talk about the
I also
impact.
think, I do believe, I just want to make one more point on the civil cases, because I do a lot of civil lawsuits. I think they like this term because if they get sued, if you get in front of a jury, let's say Richard Jewell had been in front of a jury, and they had been calling him a person of interest for all of that time rather than a suspect, they would have used that to try to minimize the damages from the jury. They would say to the jury, hey, we never said he was a suspect. He was a person of interest. There were lots of persons of interest. So I think, now whether it would work or not, I don't know, but I think that's partially what they have in the back of their mind, reducing civil liability.
All right, so civil liability is one thing. Then, of course, there's the court of public opinion. A little earlier, we had on CNN American Morning a former FBI special agent by the name of Don Clark, and he said essentially when you lead someone away in handcuffs, as this person, Raymond Clark, was in the case of Annie Lay, then really what you call them is a matter of semantics. Let's listen to him this morning on American Morning, and then we'll get you to weigh in.
Well, they can probably call it a person of interest or whatever they want to call it. I like to call it a suspect. You lead somebody away in handcuffs, they're probably a suspect.
So, Cynthia, let me ask you, in the court of a public opinion, does it really matter what you call somebody, even if person of interest is supposed to diminish the impression of culpability, if you will?
Right, in the court of public opinion, that's the point I was making. Everyone understands what we're talking about here. The eye of accusation is on this individual. He's been arrested. He's in custody. It's clear that he's a suspect in the killing of Miss Lay.
Paul, what do you think the media should do? How should journalists ensure that they are keeping their readers, their viewers accurately informed with the latest up-to-date information, while at the same time protecting an individual's precious reputation?
Well, this has always been a problem for the press. How do you balance the rights of an individual who's been accused of a crime and is presumed to be innocent against the public's right to know? And the public does have a right to know, and the public has a great interest in these cases. So, I think, number one, the press really should not necessarily be lured into the terminology that is suggested by the police. Just because the police are characterizing him as a person of interest, I wouldn't necessarily adopt that terminology. Now, most lawyers will tell you that when a person is led away in handcuffs, he's not a person of interest, he's a suspect. And you generally need probable cause to put handcuffs on a person. As Cynthia was saying earlier, a search warrant was executed in this case. That would also indicate that a judge has already found that there's probable cause to believe that a crime has been committed and that evidence related to that crime was at this suspect's apartment. So all of that points to me to the fact that this is a suspect in the case, not a person of interest. So I think the press should be careful, should make an independent judgment about how to characterize these people. And let's face it, this guy's a suspect. He's not a person of interest.
And Paul, if I could add, it would be good if the press could report progress of the case, the search warrant, and so on, but not get sucked into that perp walk photo opportunity where we see that inflammatory photo of someone in handcuffs or film when we really don't know if a crime's been committed. It'd be fair to report an arrest and leave out that inflammatory photograph of someone being let off in handcuffs. So I think it's unprofessional by the authorities to allow it to be photographed, and if the press is concerned about the individual's rights, it'd be good not to film that kind of inflammatory scene.
Well, that's an interesting thought, and, I think in a fair world, that's the way the press would handle this. But, of course, our system is very different from the English system, for instance. In England, when someone is charged with a crime, there's pretty much a press blackout with respect to all aspects of the case until it's tried in open court. Because of the First Amendment in America, we have a much more open process with respect to our court system, and the government really cannot pry or restrain the press or place restraints. And so I think, Cynthia, you're proposing a great idea, but it will never, ever happen.
The question was, how could the press be more responsible? It wasn't, how could we limit them? And I agree with you. We should never limit the press. They're very important to us. But the question was, how could the press be more responsible? That would be a way.
Yeah, of course, they never will.
Let's definitely get back to this particular topic. But before we do, I want to just head over to Reggie because he's keeping an eye on what you are saying about this matter.
Well, we asked a very simple question. We asked, what does it mean to you if you hear the term person of interest on television or read it in newspapers or on the web? And we pretty much got a universal answer from our Facebook fans. Rochelle tells us it's a person who probably did it. Okay, here's another one from Rick who says, that means suspect. Going to move on to another one of our Facebook fans, Oriel, who says, with a little more evidence, they become a suspect. I'm going to end on Carlos, who says, don't people know how to be definitive? I'm really disliking the current trend towards ambiguity and use of euphemisms, likely caused by our preoccupation with political correctness, which demands that we do not refer to things directly, but with an invented, non-offensive term. If I could just ask one question here, because I'm interested in what our attorneys are saying today about the way in which the media has been of course, showing this perp walk time and time again ever since it happened, and we have been showing it multiple times just in this segment. Isn't a part of this also public safety, guys? Because you have someone who, call him a suspect, call him a person of interest, whatever you call him, you have him, he's been, as you say, interviewed by police. There's probably a probable cause that the judge has found at this point, and now he's released. And so doesn't the public have a right to see who this person is?
You can certainly show a photo of the individual without showing him being arrested. If he's been released, then a judge has also found that he's not a danger to the community, and there are sufficient restrictions placed on him to assure us that he's not a danger to the community. So, again, it's just the photos of the person in handcuffs, not their identity and their image. Would you agree, Paul?
No, I wouldn't. I think, technically, if I were a criminal defense attorney and I was defending an individual suspect, I'd do everything possible to keep him out of the newspaper. But looking at the broader picture, I think the public wants to know and has the right to know about suspects and people of interest who are in custody. There's an enormous amount. Now let's talk about this Connecticut case for a moment. There's an enormous amount of fear on campuses in Connecticut, particularly in the Yale area. New Haven people are terrified. I think they want to know that law enforcement authorities are focusing on a particular individual, that individual is in custody. I think it conveys a sense of public safety, and the public has a right to know that. And I think that the visuals, we're a very visual society, make a big difference here. I think if you just did a generic announcement of some sort without a picture, nobody would know about it. It wouldn't get communicated. So I think as long as we have an open and free press, this stuff should be broadcast. I did not suggest it would be without a picture.
I said it's the inflammatory photo of someone in the handcuffs that tells the world, we've seen it on Facebook, this person did it. And that's simply not fair to someone who's merely accused and against whom there's only probable cause to believe that a crime has occurred.
Well, what do you do?
No
cry?
problem,
Are you going to crop the pictures?
I have no problem with showing someone's photo. I do have a problem with that in the handcuffs kind of indication they're guilty already. And you should too, Paul.
All right, we're going to have to leave it there, I think.
Thank you.
Well, to thank both of you very much, though, for our lively conversation today. That's attorney Paul Callan of Callan, Costa, Brady and Brennan, and Cynthia Hujar, president of the National Association of Criminal Defense Lawyers. Thanks to both of you.
Thank you.